Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Pinkerton versus United States. This case was heard in the Supreme Court of the United States in the year 1946. Let's go ahead and jump into the facts of the case. So there were two brothers, Daniel and Walter Pinkerton, who conspired to violate the Internal Revenue Code. Now, these two brothers were charged with the substantive offense of violating the Internal Revenue Code, in addition to a conspiracy offense. There was a conspiracy between the two to break the law, so they were both charged with conspiracy. So what is a conspiracy? A conspiracy is an agreement between two people or more to commit some substantive criminal act. Now, the argument here is from the brother Daniel. Daniel is charged with conspiracy to commit the substantive offenses that his brother had committed. Now, Daniel's saying he had no knowledge, he had no foresight that his brother was going to commit the substantive offenses that he did. He thought they were only going to commit the same substantive offenses. But his brother Walter went further and committed substantive offenses that the two had not talked about together. So he says, I shouldn't be on the hook for a conspiracy to commit these substantive offenses because me and my brother never agreed about these ones. The court does not find that argument to be convincing. The court says that if there is an agreement between two co-conspirators and the other co-conspirator acts in furtherance of that agreement, in furtherance to commit some substantive act, then you're on the hook for whatever the co-conspirator committed. There is some language at the end where it says if it's so far afield, then you probably wouldn't be responsible. But so long as there is a conspiratorial agreement, if one co-conspirator acts outside of the realm of what the other co-conspirator thought he was going to do, well, then you're going to be on the hook for a conspiracy to commit that substantive offense. So to illustrate this, let's just consider an example. Let's consider that the two brothers, Daniel and Walter again, conspired to launder money to evade taxes. Probably a pretty similar case. Now, the FBI begins to investigate Walter. And the FBI is investigating Walter. He hasn't told Daniel that the FBI is investigating him, but Walter knows that we got to get the FBI off our tail if we're going to continue to launder this money. So what he does is the FBI agent comes to visit Walter, and Walter kills the FBI agent to ensure that they're not caught in their money laundering scheme. I think this would present a difficult case for the court. Could Daniel, who didn't know that his brother was going to murder the FBI agent, be on the hook for conspiracy to murder, conspiracy to kill another person? And that's an interesting question because it might be within the scope or within the scheme and the conspiratorial agreement that the two brothers had made, because it was the express intent of Walter to kill this FBI agent so that he didn't catch them from laundering money. So could there be an argument that Daniel is on the hook for his brother's murder? Daniel's going to be charged with a conspiracy crime in relation to his brother's murder. That's something interesting to think about. I think that would take us to the edge of the Pinkerton doctrine as the court elaborated it in 1946. It's worth knowing that the MPC does not like the Pinkerton doctrine, and the reasons are probably just because of the example that we just discussed. Now, it's hard to charge someone if they didn't know that there was actually going to be some crazy crime committed. Two people conspire to rob someone, and then one of the robbers pulls out a gun and kills the other person, but the other co-conspirator didn't even know that their robber friend had a gun. How can you put them on the hook for that? It just seems a little counterintuitive, and I think that's why the MPC went away with it. But it's an interesting case, and conspiracy is something to think broadly about. Should we punish people just for agreements? It seems a little bit like we're punishing people for thought crimes rather than what they actually did. It's also worth noting that conspiracy does not merge. Now, other inchoate crimes, like attempt, will merge. So if you're charged with attempted murder, but you actually murdered someone, you're not going to be on the hook for attempted murder and murder. You'll just be on the hook for murder. But if you're charged with conspiracy to murder, and then you actually commit the substantive offense of murder, you will keep both of those counts separate and you'll be charged with both. So there's no merger doctrine that applies to conspiracy. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.